firstly, William, thank you very much for agreeing to do this interview. We're delighted to have with us William Kirtley. And it's been suggested by some that now that we have the possibility for law firms to act in the UK on a contingent fee basis, that there might be a world in which law firms and third-party funders start to compete for business. What do you think about the realities of that, based upon your experience of practicing in the US and in international arbitration, where contingency fees are used from time to time?
Yeah, I've been working, I've spent most of my career in France. Since third-party funding arrived in the US, I have been in France. So I cannot say, with respect to direct one-on-one competition, but from a purely logical perspective, I do not feel that third-party funding is creating clients who do not exist previously and who would not be covered by either bank accounts or contingency fee agreements. So I could see some competition in the future for the same clients who have the same cases, just like there's competition between lawyers in terms of the clients they would like to represent with respect to these 150 million euro disputes. There's considerable competition. I can see that occurring as well in terms of funding.
And how do you think, on a more general basis, that parties are changing their approach to arbitration in comparison to years gone by?
If anything, when I started practicing arbitration nearly a decade ago, I would say that clients were more keen on international arbitration because it truly was seen as being something which is swifter and less expensive than domestic litigation. Now, when you look at American court procedures and the costs of a typical litigation in the US, you will, on average, probably find that international arbitration is less expensive. However, if you compare it to a French litigation, for instance, the French litigation will be far less expensive. Now, what's the reason for this? The reason for this is attorneys not making a proper effort to control time and costs in the proceedings, really trying to contest every single point, knowing, or you should contest every point that is in your client's interest, but not contest things which are irrelevant for the case, and do nothing for your client in order to win that. Plus, I think that international arbitration has suffered from, because there are so many different legal cultures that have been practicing international arbitration, it has developed a significant amount of both common law and civil law attributes. So from the common law jurisdiction, we've developed extremely long hearings, such as they have in the UK, whereas from civil law jurisdictions, international arbitration has developed the possibility of very long written pleadings, overly long, 200 pages, 300 pages for a written pleading. At the same time, the document production is slowing down, and you've had developments in the US about discovery and the enforcement of awards. The procedure has become much more complex and much more like litigation, and in some ways can even be more cumbersome than litigation, which is why we're trying to really make a pitch, and this is one of my personal efforts, to encourage fast-track arbitration and time limits in arbitration clauses, whereupon arbitral tribunals have to rule within a specified time period. 6 months, for instance, I think is an entirely feasible amount of time to conduct an arbitration if it's done properly, and for an arbitral tribunal to render an award.
And in the sort of scenario, which perhaps in the scenario of a slightly poorly drafted arbitration clause in the agreement, potentially very long and difficult process, how do you find that you have to manage the client during that process throughout?
We've had experience with clients who like putting in very complex step clauses They call for, and I believe this is what you're referring to, like a multi-tier dispute resolution mechanism. I personally always counsel my clients to not include more than 2 steps, more than attempts at mediation, going directly to arbitration, because you have the risk of doing something which violates the dispute resolution clause and throws the entire procedure that was carried out following that violation into question. For instance, it could be determined that once you submit the dispute to arbitration, that in fact you should have done something else that you didn't do under the multi-tiered dispute resolution clause. And so I always warn them to avoid it to whatever extent possible, and to keep it as limited as possible, which ties into the idea of fast-track arbitration as well. Yeah. Although you can make them more complex in terms of limiting the amount of document production, and in terms of limiting the number of days of the hearings, etc.
And on a general basis, what do you think makes somebody a good litigator?
I think being a good litigation partner, you have to have a good grasp of the strategy of the case, but you also have to have the time that you're willing to devote to the case and to actually read the documents and to actually go page by page by page and help to construct the case on your own. And I've seen too many arbitrators and litigators who outsource absolutely everything, who delegate absolutely everything, just show up at a hearing with a pretty face, and some of them are very well known and highly respected, and I respect them as individuals. I know that they're brilliant, but it is impossible for many of the lawyers practicing arbitration today to be engaged in the number of projects that they are doing without relying on others to do the work, and that's not what the client wants. I mean, to give what the client wants, the client is expecting an experienced attorney who has the time and energy to do his maximum to ensure that the client is successful in the arbitration, instead of having a first-year associate working on the case. Which I've seen in my legal practice, and I think it's an unfortunate practice.
And what made you decide to become a lawyer?
I come from a long line of lawyers. My grandfather was a lawyer back in Kentucky. His name was Willie Williams, and he fought for the abolition of the death penalty in the U.S. And he even defended the last man ever publicly hung in the U.S. He lost. He lost, but it was pretty certain he was going to lose, because it involved an African American man who had raped an elderly white woman, and at the time in the South, there was racial segregation, and in places like Kentucky. So it was a losing case, but they did take it on, and he helped to try, and soon afterwards they did manage to at least ban public executions. And it was an outcry from the scandal of seeing 60,000 people gathered during the spectacle of a black man being hung that helped lead to outrage in the abolition of it. So that is nice, of public executions, although, of course, the U.S. still likes to execute individuals far too often. And also, my father's a lawyer, my uncle's a lawyer, my grandmother was a lawyer. She was the first woman president of the Kentucky Bar Association. She was also in the Kentucky Senate. So it's in the family. When after Harvard, when I went to Africa with the American Peace Corps, I was certain that I wanted to go into law. I was not certain which domain. I discovered, I worked quite a bit with the United Nations and the World Bank, and I discovered international law. And I thought that international arbitration would be very interesting for me, along with being a lawyer. I'd already always known I was going to be a lawyer. And I haven't been deceived. It's always stimulating and continually challenging and always exciting.
And it seems almost inconceivable in light of that, but what would you do if you weren't a lawyer?
Yeah. I entertained being pre-med for a while at Harvard when I was a freshman, but I'm glad I decided not to.